My pleasure, Lordships.
Yes.
I pick the mention hearing item 15. Hearing item 15.
Yes.
Lordship, on the last occasion, this honorable court have directed me to go through the writ appeal to the 7th of 2022. That is today. I've gone through it, your Lordship. And then there's a slight chance that my review may not succeed.
No. There is actually a complete overturn in this
Yes,
case.
Lord.
Because after the division bench had of Justice Suman Sham and Justice Borough had passed the order,
Yes, Lord.
again, like Justice Robin and Justice Habung, they have passed a contradictory order.
Yes, Lord.
And the state government has taken that appeal, order in appeal before the Supreme Court.
Yes, Lord.
So yesterday also we had passed certain orders asking that the matter may be listed only after disposal of the case by the honorable.
Yes, I have the same, your Lordship. Since I was informed that they have also filed a review petition against the writ appeal 7 of 22.
Review as well as appeal.
Yes, Lord.
So now the appeal is more important. Appeal that
Yes,
is
Lord.
before the Supreme Court.
So if My matter may be listed after the disposal of the same.
Okay, after 4 weeks, okay?
Yes, Lordship.
On the prayer of the learned counsel for the parties, listed after 4 weeks. And next day, if there is any order from the Honorable Supreme Court, kindly place it. Okay?
Obliged, Lordship.
Yes. If not, we were of the view that you do not have a very good case.
I understand, Your Lordship. Obliged, Lord.
Perhaps Lordships, I
Yes.
mentioned item 29 and 30. Lordships, in item 29, I am for the appellant. In item 30, I'm for the respondents. 9 and 10, I'm yet to file my affidavit.
Item 29.
29, 30, they're both tagged together. That is,
Okay, item
Which is the
29.
same.
So in WA 1224, you are yet to file
affidavit in opposition.
on affidavit in opposition. You are for the respondent number?
9 and 10, Lordship. Respondent 9 and 10.
Yes. What about the others?
Lordship, I'm for R1, 2, and 3. And I also require further time for the reason that many of the pleadings are missing in the appeal memo, Lordship.
Okay. Mr. Iralu,
And for the respondent 1 to 3 in item 29.
1, 2, 3.
Item 29, yes.
In item 29, 1, 2, 3. You are for item 1 to 3 in, you are for 1 to 3 in item,
29.
oh, you are
I am
together?
for 30, item 30 are for 1 to 3.
You are 1 to 3.
Yes, my apologies.
My lords, may I say this in item 2930,
Huh.
we are the appellants. Right?
Huh.
My lords, they are taking time. My lords, any fixed date may be given.
Yes, Advocate General, sir. Any submission?
Appearing in item 13 and 14,
Item third,
hearing, I think it is.
okay, then just wait, please wait,
Wait, yes, I'll-
please wait. So item 29,
Item 29, my lords, I am for the appellant. My lord, this matter has been adjourned for a few times. It's
who
a
is
request.
the
that-
appellant in item 30?
Lordship, I am for the appellant.
You are for the appellant in
Lordship.
item. Okay,
Last time also, my lords, they had wanted a hard copy, though they had the soft copy. It's fine, my lords, but my lords, there has to, my lord, any date may be fixed so that we can take up for hearing. So it's just a request, your lordships.
let them first file their affidavit. After that, we'll take up for a hearing.
Lordship, if the matter can come up for 2-3 weeks, Lordship, as per the convening of this honorable court. So that the
Any
all,
date after 3 weeks. Any date after 3 weeks, your lordships.
In item 12, who is for respondent 1, 2, and 3? Iralu, you are
I'm for respondent 1 to 3 in item 30.
1, 2, and 3.
Item,
You have filed your affidavit.
I have filed.
You have filed. Who is yet to file? 9 and 10. 9 and
Lordship,
10.
9 and 10, Lordship, as well as the private respondents.
No, private, you are for item 30, item 30.
I'm the appellant in 30.
No, 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 you are respondent number 1, 2, and 3 in item 30.
Lordship, 29.
Okay, okay, okay. Mr. So-and-so, your good name?
Aliza Kire.
The learned counsel for the respondent number 1, 2, and 3. And Mr. Fuseko Fote, the learned counsel for the respondent number 9 and 10. In WA 12/2024. 6 for further 3 weeks' time to file affidavit in opposition. What about 30?
Lordship, 30 pleadings are all completed.
Okay, okay. Prayer
Both
is,
are connected, your lords.
prayer is allowed? Listed again on. 18-9, okay.
Very well.
18-9-2024, okay.
Lordship. I would like. Lordship, I also like to mention item number 16. 16, Lordship, I'm for the respondent. 16, Lordship. I'm for the respondent, Lordship.
Yes, item 16.
Sole respondent. Lordship, if the matter can come up after 2 weeks, Lordship. It's a criminal appeal filed by the state.
What is the matter?
Lordship, here against conviction, Lordship. The state is filed an appeal against conviction of the respondent, sole respondent.
Sole respondent.
Sentence has been under.
Where is no line? Okay, after some time. This is where AG is appearing.
No, Lordship. I'm here, Lordship. Item 16, I'm here.
Our learned AG was mentioning about item 16.
I think Lordship.
13 and 14, I think.
13 and 14.
14.
Okay, this is 16.
16, Lordship.
On the prayer of Mr. Fuseko 40, the learned counsel for the sole respondent. Listed after a week.
2 weeks, Lordship. Kindly.
Listed after.
2 weeks.
Flash law.
I will like.
My pleasure, your lordships.
Yes.
Lordships, I beg to mention item number 26, 27, and 28, lordship. Lordship, I've taken the consent of the opposite parties, lordship. I pray this matter be
Item?
listed. 26, 27, and 28.
There's no 28. There's only 26, 27. But. Oh. 26, 27, 28.
Lordship.
You are the counsel body?
Petitioner, lordship. Lordship, I pray this matter be listed on 4th of September for final disposal, lordship.
Why that auspicious date? On the prayer of Mr. So-and-so, the learned counsel for the petitioner. This is a challenge to the rules.
Lordship, lordship.
Mr. So-and-so,
And also the
learned counsel for
seniority,
the
lordship.
Petitioner listed again on 4/9/2024.
Much obliged.
Well, please, your lordships,
Yes, please.
I beg to mention item number 17 to 25.
Ah.
The lordship,
Analogous.
similar nature is pending before the Supreme Court. So I believe this matter may be listed after 2 weeks.
Let's produce that particulars.
The lordship, I have a case diary number
Uh,
22747. 22747
22747
of
of
2024.
what is the matter in this case? What is the matter?
This is appeal against the regularization of service.
My lord, here petitioner was released from the service after serving for 35 years on fixed pay. So in the single bench order, the learner single bench has directed the state respondent to consider the petitioner case.
With a retrospective.
Yes, my lord. That is why the state is before the appeal, my lord.
Okay, let us see it next on the prayer of Mr. So and so, learned counsel for the respondent, listed again after 2 weeks. Okay.
Much obliged.
Yes, where is it? What to do? He is for which item? 13 and 14. Yes, please.
Is it 13 and 14?
Ah,
In this matter, there appears to be some confusion as to which will be the appellate authority when orders are passed from the village courts. Now, this very issue is now seized off by the government as a very serious matter, because now we are constituting by notification all the customary courts which have been provided under Rule 4A. And that is going to specify exactly which would be the one of original jurisdiction and which would be the appellate jurisdiction.
what
That
is,
is the
learned AG, what is a rule 4A?
Rule 4A of the
Rule 4A.
Administration, Justice and Police in Nagaland.
Chapter
That deals
4A,
with
Your Lordship.
customary court. That deals with customary courts.
Chapter 4A
Ah,
of the
correct.
rules.
4A.
Yes.
That's
Chapter 4A. That is yet to be
That is
enforced.
yet to be gazetted.
Yes. And that is the
We are
constitution of customary courts and appellate courts for the customary.
Mr. Iralu, precisely what is the issue involved in this case?
The issue in this case is that while passing the order in the case of Registrar General versus Arunachal Pradesh and the states. Now, on the premise of there exist customary courts in Nagaland. Now the court has more or less set aside or more or less repealed the rules or done away with the rules, saving the provisions or the procedures for the courts of customary courts. Now, what has gone wrong is that while briefing the courts by the councils, one wrong, the exact picture of the rule has not been brought to the notice of the court, because the spirit of CPC applies to the course of ADC and assistant to DCs, then we call it. It has nothing to do with the village course, like the course of GB or Dubashis. Now, what has gone wrong is that in the order, in the case of Registrar General, now the court has reflected on the submissions of the amicus curiae that the spirit of CPC applies only to the customary courts. That is the village courts.
Spirit of CPC applies only to the customary.
Yes, to the village courts, which is contrary to Rule 35 of the rules. And from there, it has gone wrong. Because so far, we have no customary courts whatsoever. And Chapter 4A is yet to be enforced. From there, this confusion has come up. And since the rule has been done away with by that division bench order, now where do appeal lies? From the courts of village councils or Dubashis or Ganburas. Where do we go? Because since rule has been done away with, we approach the civil courts, civil judge, senior or junior or district assistant judge. Now they said they had no jurisdiction to attend the appeals.
from those courts. Whereas the Gamburas, the Bashis, or including the village courts, have never been declared as a customary court. Only in 2022, the government issued a notification describing the village council as village court. And as per that notification, appeal from the village court lies to subordinate district customary court, which doesn't exist. That is the problem.
What is the issue in the present case? In the present case, it is against the order or judgment passed by
The first one is his case. The second one is my case. Now, in my case, against the decisions of the village council, I preferred an appeal before the senior judge, civil senior judge division.
And the
Now,
senior civil judge says that he has no jurisdiction.
He says he has no
He
jurisdiction.
has not been empowered.
Yes. And in his case, same.
I think, is this issue not before the division bench?
It has
In the
not
principal
been
sit.
brought, it has not been properly brought to the notice of the court. That's why the problem has come up.
I think we have to
Because-
make a reference.
Because of that,
To a larger bench.
this is because of that reference.
Oh,
Reference is by His Lordship Arun Dev Chaudhary. So in his case, out of his case, reference has been made, and this is why it is here now. This is out of reference.
So we have to decide whether actually the civil judge senior division has the jurisdiction to try the case in appeal.
Yes,
From
and
the
the other
decision of-
issue is whether there is a customary court, whether chapter 4A of the rules is applied
Yes,
or not.
Mr. Leonard AG.
We are seized of this problem. In
Issue
fact,
next.
last time, we had a detailed discussion on this issue.
Yes.
I discussed the matter with the government also. And we are trying to find a solution which we will find very shortly in this matter. Because though there is provision for these courts, notification to that extent may not have been issued. Now we are in the process of completing that process along with the separation of executive from judiciary. We are bringing out everything, streamlining everything that so that this type of confusion doesn't exist. The statutory position is these three customary courts do exist. And as my learned friend had said that he is not in a position to file an appeal. Therefore, to avoid these type of irregularities, two methods are there. For the moment, I would suggest that since the government is seized of the matter, we will come out with a suitable solution with this, which I shall present before your lordships. Supposing for any reason, it needs a reference to a larger bench also. I'm examining that also. Because at that time, you recollect that we had nothing to do with CPC. By an innocuous order, they pasted it on our state also, though it is only with the spirit of it. Therefore, permit the state, which has done a lot, we have had a lot of meetings on this at the highest level. And I think we are coming out with a solution which would solve this problem. And thereafter, if this honorable court is of the view that a reference would be made, I would definitely welcome it. But as a first step, let the state come out with its position. So I will require about some time, reasonable time this honorable court may give me. Then I will report back to the court because this is not an adversarial litigation. We are just trying to find out a solution. The problem may be genuine, and I'm sure we'll come out with a proper solution. So give me some reasonable time. I'll report back to the court. Then supposing it comes out, the reference has to be made. We can make a reference. We can straight away make a reference also. But since the government is seized of the matter and we are at quite an advanced stage, let us have the liberty to go ahead with this matter. That's what I would suggest, instead of giving any finding on it at this stage. We should solve the problem. Definitely, we should solve the problem. We have had such strange problems from time to time, and we have solved it. So I don't think that this will be an exception. We'll do it.
Mr. Limawa, the learned counsel for the petitioner in Civil Revision 5/2020, 2020, and Mr. R. Iralu, the senior counsel, assisted by Mr. L. Iralu, learned counsel for the appellant in Civil Revision 6/2021. Stop. Also heard Mr. A. Balgopal, the learned, and I'm sorry.
With Nitya Nambiar and the standing government advocate also.
Learned Advocate General, assisted by MS Nitya
Nambiar. Yes. Nambiar, NMBIAR,
Nitya Nambiar,
and the government lawyer, learned government counsel, Mr. Empton.
and Mr. Moimchin, the learned senior government advocate for the state respondents. This is a reference.
Yes.
The issue on the reference is as to whether the civil courts in the state of Nagaland has been empowered.
Your lordship, civil courts, regular civil courts.
The statutory
Yes.
civil courts, the statutory civil courts in the state of Nagaland has been empowered to adjudicate cases on a decision passed by the village council / DB's court. Mr. N. Balgopal, the
Yeah.
learned Advocate General, Nagaland, submits that the government is seized of the matter and is in the progress of coming up with a suitable solution to address the issue which is pending before this court. And therefore seeks for some time to come up with the necessary instructions. Okay. Okay.
Yes, limited time may be given.
In view of the submissions made by learned Advocate General Nagaland, leaves the case again on. Yes, sir, convenient date.
The end of September or first week of October, so that we may have one or two meetings. Even I'll be personally present in the meetings. I would like to join those meetings with the government.
Yes, yes, I would also love to meet you. List it again on,
Any date you may fix.
can we have it on 16th October?
Okay.
Very well, very well.
October. List it again on 16th
16th October.
2024, on which it is expected that the learned Advocate General will come up with necessary instructions
I'm great.
on the matter. Okay.
I'm great.
Oblige, your lordship.
For motion, item number 1.
Yes.
My lord. My lord, the petitioner is an.
Issue notice. Heard, Mr. So-and-so. Learned counsel for the petitioner. The present petition has been filed. Seeking for a direction. To quash the detention order dated 30/5/2024. Issued by the Special Secretary to the Government of Nagaland. Under the PIT NDPS Act 1988. Stop. Issue notice to the respondents, returnable after 4 weeks.
I'm appearing for respondent 1, 2, and 3.
What about CGC? Mr. E. Tibapon, the learned government advocate, appears for the respondent number 1, 2, and 3. Therefore, no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within
2 days. Lord.
within a period of 2 days from today. Insofar as the respondent number 4 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents, upon the respondent number 4 by registered post with AD within a period of
2 working days. Lord.
2 days from today.
Much obliged. Obliged, Lord.
For motion from the supplementary cost list, item number 32.
Yes, we issue notice, Lordship. Heard, Mr. So-and-so. Learned counsel for the petitioner. But where is your detention order?
Lordship, detention order is on page, the first one, Lordship,
Page 14.
Lordship.
No, that is grounds of detention.
No, this is the order, Lordship. This is the final order, Lordship. Page 14.
This cannot be. Mr. Ithiba, is it
No.
this is not a detention
It's not a
order.
detention order.
This is only the grounds of detention. This is not the
Lordship.
detention.
This is the final order, Lordship. We have received this, Lordship. Only after receiving of this, Lordship, detention,
No. We cannot pass any order.
the 35/2024, Lordship. Order.
This is not the detention order, Mr. Counsel. These are only grounds of detention. The formal order you have not enclosed.
But,
No, but
till date we have received this only, Lordship.
you make inquiries and come.
You can obtain the instruction. Lordship, the state can obtain the instruction, Lordship, the final order.
You first annex your detention order. Don't put the responsibility on the state.
But Lordship,
Listed again on
can it be on 30, Lordship?
38.
38/2024. On which date the learned counsel for the petitioner shall place the formal detention order.
Much of
For admission, item number 2.
May I please, your lordship?
Yes, Mr. Taka. I think
Lordship, last 3 orders are very clear, but I leave it to Lordship. I have nothing to say. Because once the court orders are there, I have nothing to say.
I think I am not destined to face this case.
Because the last 3 orders, last chance given. But then if they still insist, I have nothing to say.
They have filed letter of absence also.
Yes, some personal difficulties, your lordship. That's
Okay.
which is unavoidable.
Okay. I think this time it is your date.
Yes.
It
They
is
didn't
your
give a
date.
They didn't give a very, last time he was asking for a very long date, he can ask for a short date today.
Yes, it is your date. We give you that, at least that liberty. I think this court has on many occasions fixed dates and also made an observation that endeavor shall be made to dispose the case, but maybe,
Let it be fixed on 28th of August, your lordship.
Mr. I.
Yes, your lordship.
Learned Counsel makes a mention on behalf of Mr. C.T. Jamir, the Learned Senior Counsel for the appellant.
Yes.
for the appellant, and seeks adjournment of the case on 28/8/2024. This court by the order dated 24/7/2024 had observed that no further adjournment shall be granted and an endeavor shall be made to dispose the case on the next date fixed. Stop. Thereafter, even on the next date, that is 6/8/2024, the case was adjourned on the ground that Mr. C.T. Jamir, the Learned Senior Counsel, was indisposed. In view of the earlier order passed by this court, it is made abundantly clear that an endeavor shall be made to dispose the case on the next date fixed without fail, listed accordingly. Please. Okay, next
Yes,
time,
lord. Yes, lordship.
let your senior come.
Much obliged.
For admission, item number 3.
Yes, Mr. Joshua, what has happened to this case?
Lordship, I filed an affidavit yesterday explaining all the practical difficulties that has been faced by the contractor. And this matter also, your lordships are aware that it is pending before the Honorable Supreme Court as well. And it is fixed on 3rd of
Pendency
December.
before the Supreme Court does not give you the right to stop the work out.
No, Lordship, as far as the work is concerned, it's going on. But what I mean to apprise your lordships is that the issue of ROW is also pending before the Honorable Supreme Court. And the last affidavit that we have filed also, Your Lordship, if this honorable court would like to peruse, we can produce it on the next date, Your Lordships, the affidavit that has been filed before the Honorable Supreme Court.
Well, where is that affidavit?
My Lord,
No, where is that affidavit?
our affidavit that we filed yesterday.
Yes. But there is a direction to work within the ROW.
The Lordships will kindly appreciate this aspect. These are technical matters. And my Lord, technically, what would result into danger for the commuters and the public at large? My Lord, that has to be appreciated where the technical aspect. There's many a times in the catena of decisions, my lords are aware that.
Let us
technical
now
aspects
forget
are
about the
used.
technical aspect. Let us concentrate on the others passed by this code with regard to the right of way.
That is why, your lordship.
At least, actually, there is an order. If actually
No,
there
my
is
lord.
some difficulty
Yes. your
in
lordship.
complying with that order, then you could have actually come before this court with a proper application.
That is the reason why now, my lord, after getting the permission of this honorable court, we have been working on all out to finish the work
What is the percentage of work you have completed as per your last affidavit?
as per the last affidavit.
It's 73.55%.
What is the affidavit dated? What is the affidavit dated?
Lordship, I'm referring to the last order. Passed
No,
in
you have a
1964.
file affidavit only yesterday.
No, the last affidavit, my lord is talking about the last affidavit, it was filed on 19th of
19th
June.
of?
June.
And
It was filed
thereafter, any affidavit
Yesterday, my
filed?
lord, yesterday we have filed an affidavit, 13/8/2024,
13/8.
my lord. No. Yesterday's affidavit is only to point out the areas where work cannot be executed in the manner it is desired by the people or by this honorable court, your lordship. My lord, as per the Indian Road Standard, Indian Road Congress, IRC, the road should be 18 meters. But lordship, it should not be lesser than 12.92
See,
meters.
Mr. Joshua,
My lord.
I think all these technical issues, I think this is not the time to state all these issues before this court, because actually there's a direction passed by this court asking the contractor to work within the right of way. At least that order is there.
That is why, your lordship, now the practical problem is that as we finish the road, the construction, the final layer, the road will get elevated. On elevation, the size of the road, naturally, it is narrowed. And in most of the stretches which is already mentioned in this affidavit, your
Okay,
lordship.
where is Mr. A. Jimomi?
My lord, today he had some personal
Please tell him to come
difficulties.
next week.
Lordship,
Please
lordship.
tell him to come next week,
Yes, lordship.
so that he can also examine the stand taken by the contractor.
Lordship,
Below.
lordship,
Let him come next week, okay?
lordship, lordship.
Will he be available?
Lordship, he will be available,
Please
lordship.
tell him to come next week,
Yes, lordship.
so
I
that
will.
he can also examine the affidavit
My
filed
lord.
by the contractor,
Lordship.
Yes, lordship.
and he can apprise this court. I think his service is very much required.
Lordship, I will convey that to him.
Okay,
Yes, lordship.
MS Lucino. The learned counsel submits that. Mr. A. Jimomi, the learned amicus curiae, has some difficulties today. Stop. This court desires the presence of the learned amicus curiae, so as to enable him to apprise this court on the affidavits filed by the contractor as well as by the NHIDCL.
Also, that file affidavit this morning, but on perusal of the affidavit filed by contractor. If I may be allowed to get some instruction.
Okay, next date you, okay. listed again on. Twenty-one, okay. Listed again on 21/8/2024. Please tell Mr. Jamomi,
Lordship, I will.
okay, that the court requires his assistance.
Lordship,
Lordships.
oblige.
For admission, item number 4. Please, Lordship.
Yes, please.
Lordship, I beg to mention on behalf of my senior, who is the standing counsel here, Lordship.
Who is,
Ajo, Lordship.
he is the standing counsel of what?
No, leading counsel, Lordship.
Oh.
I'm sorry, Lordship. Lordship, I have taken the consent of the learned additional advocate general. Lordship, we have a consensus prayer here. If your Lordship may be gracious to list this matter after 2 weeks, Lordship.
On the prayer of Mr. So-and-so. Learned counsel for the petition. List the case after 2 weeks.
Lordship, there's an interim.
The same is not stop. The same is not objected to by the learned government. Stop. The interim order passed earlier should continue till the next return.
Much obliged.
Much obliged.
For admission, item number 5.
Yes.
May please, your lordship.
Yes.
Kindly this matter may be adjourned and then listed after 2 weeks.
Okay. You are the appellant.
Yeah, no, I'm
And
for the
for the
respondent.
appellant, my lord.
You're the appellant.
Yes.
On the prayer of Mr. Ayimchan,
Yes.
learned counsel for the respondent,
Private respondents, yes.
learned counsel for the private respondent, listed after 2 weeks.
Yes, your lordship. Your lordship, there is an analogous matter which has to be clubbed with this, the item number
Item number
5,
5, 6,
6,
8
and
and
8.
9, my lord.
5, 6,
8 and
8 and
9.
9.
so 6 and 8 will have to be clubbed. We have passed order in item 5.
Yes,
Correct?
Yes.
yes.
5 and 6, 5, 6, 8 and 9, my lord.
8 and 9.
Yes.
So we will have to take 6, 8 and 9.
Yes,
Correct.
yes,
my
yes,
lord.
along with the
To be
5.
clubbed together, item number 5.
WS 7/2024, IA Civil 75/2024, and WA 14/2024, along with the present. Okay.
Much obliged.
For admission, item number 7.
Lordship, the IA praying for interim may be considered.
What is the IA?
My lord, not to recover the MSCP till the disposal of the case. If I succeed, then it will be automatically regularized.
Where is your IA?
My lord,
Mr. Taka, your IA, let us see, which IA?
Lordship, IA,
IA 40?
yes, Lordship.
IA 40.
Lordship, may kindly see paragraph 3. Paragraph 3 and 4. 3, 4, and 5. Lordship, if necessary, I may give a brief gist of the writ appeal.
Your case in the writ petition was claiming a retrospective regularization.
Lordship, kindly allow me to make a submission. It is not a case of, apparently it looks like a retrospective regularization, but the grievance issue is, my lord, arbitrary application of a different standard to the writ petitioner. Appellant. Lordship is like this. The petitioner appellant was appointed on contract as a teacher on 12/3/1993, Lordship. Then Lordship, a memorandum was, the government of Nagaland had issued a memorandum on 18/2/2024, where 5 years and 10 years continuous service were regularized. Lordship, my case was also recommended. However, I was not considered for regularization. And my juniors who had completed 10 years in 5 years of service were regularized. I was left out. The others were regularized with effect from 16/1/2004, whereas Lordship, I was regularized only with effect from 5/7/2010. So, my lord, I filed a writ petition. Now, my lord, relying on the judgment of this honorable court, which says that when there is a challenge to the general administrative action with regard to regularization, observation, and fixation of seniority being violative of Article 14 and 16, the process are analogous to those in which the constitutionality of a statutory rule regulating the seniority of the government servant is challenged. In such as proceedings, the necessary parties to be implemented are those against whom relief is sought and in whose absence the effective decision cannot be rendered. In that particular case of the Supreme Court, Lordship, GM South Central Railway's case, my lord, Honorable Supreme Court says that only the necessary party, not the proper parties, will be implemented. That is the private respondents. So, my lord, in this case, since I challenged the principle of regularization, I did not implement, I did not challenge the seniority list. I did not challenge the promotions. I only challenged that a wrong principle was applied to me. So, relying on that judgment of the Supreme Court, I implemented only the necessary party, that is the government, without whom the decision cannot be made. Now, the learner single judge, that is one. Now, Lordship, I was given senior scale of pay on completion of 10 years on 24/3/2008, counting from my date of appointment. Thereafter, Lordship, MSCP was granted to me on 16/9/2014 on completion of 10 years of service with effect from taking the date as 16/1/2004. Now, my lord, then I came before this honorable court, challenge the arbitrary application of the regularization policy against me. Now, what has happened is, in the affidavit in opposition filed by the respondents, my lord, a document was annexed, which is an annexure A to the IA, that MSCP was wrongly given to me. It should happen from the date, it should be counted from the date of regularization, which is under challenge, not from 16/1/2004, on which the others were regularized, which was given to me.
You were not regularized on that day.
Lordship. But MSCP was counted from that day, I was paid as early as, Lordship,
So, Mr.
2014.
Taka, it is a case where you have been wrongly paid the MSCP,
No,
MSCP before your
The
regularization.
issue is this, there is no fraud involved. There is no fraud involved in the case. If I succeed in the writ petition, if I succeed in the writ appeal, Lordship, MSCP will be automatically regularized. That is the issue.
If you don't,
then that will be a different issue. So my humble respectful submission is, let this matter may be fixed for hearing next week immediately. Until then, my lord, interim may be issued.
no interim. No, sir. We will fix, give an early date, but no
My
interim.
lord, if that is so, I leave it to your lordship, but then the judgment of the Honorable Supreme Courts are clear. When, lordship, kindly allow me a submission there. When, lordship, I'll satisfy your judgment, satisfy your lordship if you insist. My lord, there are several judgments of the Supreme Court which says when MSCP is wrongly given, and if there is no fraud involved by the petitioner, then no recovery. There are judgments. So in my respectful submission, that my case will be squarely governed by this decision. But in this juncture, lordship, My lord, there will be at least, not only one, there are several judgments on that. The only issue on this, insist by this honorable court as well as the apex court is whether there is any fraud involved on the part of the petitioner for giving.
See,
If there is no fraud involved,
what you are submitting was not the issue involved in the writ petition.
my lord,
See,
the issue is this.
the issue is
My lord,
retrospective
My lord,
regularization in the
the
writ
issue is this.
petition.
The issue is
This
this.
issue was never raised.
My lord, I'm coming to that. I'm coming to that. In the affidavit in opposition, this issue was raised for the first time by the government in their affidavit in opposition. That is what I am saying. So, my lord, the matter was heard according immediately after the file because the understanding was if we succeed, then automatically the date of regularization goes back to 2004, so the payment will be regularized the moment I succeed. That's why, my lord, with that, because lordship may kindly see in an extra add the head notes, WBC 126. And it was brought only in the affidavit in opposition at the latest stage. So we immediately goes for disposal. In that particular circumstances.
That's why, Mr. Taka,
Lordship.
I am actually saying that this issue of this MSCP
Yes.
was not the issue before the learned single bench.
My lord,
So now how do we
My
go
lord, the
into
issue
this
is-
issue?
my lord, the issue is.
You first succeed.
My lord, the question
You
is.
first succeed as to whether you have
My
a
lord-
right for
My lord,
retrospective
the-
regularization.
My lord, the question is this. The cause of action, the lordship is rarely pointed out, and the cause of action, whether there was any cause of action. Now, my lord, the cause of action to agitate this issue came for the first time when the state government filed their affidavit in opposition. Not before that, because till then, there was no notice to me for recovery. The cause of action arises when they file their affidavit in opposition, not when I file my writ petition. So immediately, this issue also was raised before the learned single bench. Since it is part of the document, we raised this issue. Learned single judge brushed it aside and simply rejected the petition. That is how, my lord, since the cause of election, the foundation can be established.
I am actually telling you that since this issue was not actually decided by the learned single judge,
Lordship,
how do we now
My lord,
decide this issue?
my lord, the only issue is this. That in the peculiar facts and circumstances.
Because see, just
My lord,
briefly,
Yes,
if you succeed
yes,
in the appeal,
yes,
you are entitled to the MSCP benefits. If you
yes.
succeed in the
Yes.
appeal, if you don't, then maybe
It will be a different course of
different
action.
course of action.
My humble submission, Lord, that is why the reason why I'm bringing it to you, because as a matter of content caution, why I'm raising this issue is, my lord, tomorrow they recover and I succeed, the writ appeal.
They will pay you back.
My lord, that's why in that particular facts and circumstances of the case, I'm making a submission that till then,
No, we fix the date. We fix the date.
I have no
Early hearing.
problem. I have no problem if we go for expeditious disposal so that this issue will be resolved.
Yes, Mr. Nangami, you are for the government?
Yes, my lord.
Yes, we fix the next week.
Okay, my lord.
Next week, and this IA shall also be heard along.
Lordship, no issue.
Okay.
That way, my lord, it will solve all the problems for me also.
Because this code, at this juncture, we are not willing to grant you any interest.
My lord, on the technicality issue, I understand, but then in the peculiar facts and circumstances, because from day one, had I been informed, or if a notice would have been issued, then that would have been challenged.
Heard Mr. Takamasa, the Learned Senior Counsel assisted by Mr. So-and-so. And Mr. Nangami, the Learned Senior Government Advocate for the state respondents. Considering that the appeal needs expeditious disposal listed on 21.
Lordship,
Okay, listed on 21/8/2024. Stop. The ISC 40/2024 shall also be heard along with the main appeal.
yes, Lordship.
Obliged.
Yes.
For admission, item number 10.
Lordship, I haven't received any instruction, so I'm given another 2 weeks time.
What is the case, Mr. Younger?
Discharge,
Discharge from service?
yes.
Mr. Younger Wati, the Leonard CGC submits that he is yet to receive instructions and therefore seeks for 3 weeks time. Prayer is allowed, listed according.
For orders, item numbers 11 and 12.
May it please your lordships.
Yes, please.
My lords, the petition for continuation of 44 days is pending before the Honorable Court. And because of the notice issue,
Huh.
this Honorable Court permitted us to serve the notice through dusty service by order dated 22/5/2024. Then my client approached the private respondent twice, who was the petitioner, the earlier petitioner, now the private respondent. But on both occasions, he has refused to accept the notice, saying that the matter is already settled. So I filed an affidavit on 18/6/20 to this effect.
18/6. This is an affidavit filed by the appellant, correct? By the
Well-
appellant.
Yes, yes, your lordship. He tried to serve the notice twice, one on 10/6/2024.
Who is respondent number 1?
Respondent number 1.
Who is respondent number 1?
Lord, that will be the state. Oh, he's the sole respondent, your lordship, the main respondent
In the,
in the appeal. So notice was served upon
just wait.
my lord, my lord.
To dusty, use the non-determined. Respondent number 1. Except, I think, respondent number 1,
My lord.
if it is, it is in the IA, then respondent number, I think, respondent number 1. It should be. Oh, this, Thongbemo,
My lord.
Thongbemo,
Yes, your lordship.
he is the respondent number 1.
My lord. In the writ petition before the learned single bench, I was a private respondent alongside the state. Now the state are,
No, why this application? Why this application for? Is a limitation applicable? Is the law of limitation applicable?
your lordship, it is an appeal from the single bench. to-
It's a continuation.
Yes, my lord.
And limitation is not applied to writ petitions. So appeal is a continuation of the writ petition. So
My lord.
I think anyhow, as a matter of abundant caution, you have find this.
Yes, your lordship.
But I think what is the reason?
No, your lordship, there are 3 points. Number 1, I was also appointed without following the constitutional scheme.
Okay.
I was also appointed without constitutional scheme, which is admitted.
No. Why? I am asking you.
Yes, your lordship.
Why actually why the delay? Why the delay?
Oh, your lordship, the appellant was trying to look for counsels, and it took
Where have you stated?
in the limitation petition, your lordship.
Where have you stated the grounds?
My lord. Paragraph 11 at page 6, my lord.
Paragraph 11,
Page 6.
11.
May I read, my lords?
Yes.
The point number 1 is that appellant received the order dated 28/8/2023 passed by the learned single judge in the second week of September. He was only conveyed about the same after a lapse of about almost 2 weeks. Number two, the appellant/applicant, after receiving the review petition order dated 28/8/2023, started collecting the necessary documents, and only in the month of November 2023, he received the whole document. Thereafter, he started searching for a new counsel to represent him. The applicant, being a resident of Okozo village, Waka, took almost a month in search of a new counsel from Kohima. However, after consulting the present counsel, he was informed that the vacation has started from the second week of December 2023 till second week of January 2024. Therefore, the appellant/applicant approached the present counsel in the second week of January 2024 to file the present appeal. The present counsels received all the necessary documents in the second week of January 2024. Till then has been preparing for the present appeal. In the premise, there is a delay of 144 days.
That Mr. Joshua Shakti, the learned counsel for the applicant. The present application has been filed under Section 5 of the Limitation Act 1963, praying for condonation of delay of 144 days. In filing the connected appeal against the order dated 28/8/2023, passed by the learned single judge in review petition number 223, correct?
Yes, my lord.
The grounds for the delay has been cited in paragraph 11 of the application. Stop. We have perused the application, more particularly paragraph 11. And we are satisfied that the applicant has been able to satisfactorily explain the delay of 144 days in filing the connected appeal. Stop. The application is accordingly allowed by condoning the delay of 144 days. Application stands disposed.
Oblige your lordship.
Okay,
Main
just before application stands disposed, Mr. E. Tibapong, learned government advocate, appears for the
Respondent number 2 to 5.
appears for the respondent number 2. Well done in the main listing.
Yes, my lord.
Stop. This is a WA, na?
Yes, my lord.
In view of the order passed by this court in IA 2C 2024. The appeal is admitted to be heard. Listed for hearing. Yes,
My lord, after 2 weeks, my lord.
listed for hearing, not after 2 weeks.
Oblige your lord.
Much obliged.
For hearing, item number 31.
Yes.
May I bless Lordship. Lordship, the writ petition filed by the present appellant was dismissed by the bench.
If this is going to take long, maybe
Lordship, the issue is very limited.
this court may be disabled.
Whether there is delay in approaching the writ court. That is the only issue, not on merit. Because my writ petition was dismissed on the ground that
Okay.
there is a delay.
We list it next week. We list it next week. Listed again on,
On next Wednesday, Lordship.
yes, 21/8. 2024. Because this court may never sit again.
Chief Justice Bobby, बनाई ना है, उन्हें ना रख दे भी।